Hi, I'm Madhuri Pilania of Symbiosis Law School, Noida, a first-year student pursuing BBLLB. So here's a short video on Employment Compensation Act 1923. So this act provides payment in the form of compensation to employees by the employers if in case an employee is hurt during the course of employment. Earlier, this act was known as Workmen Compensation Act 1923. So, to be eligible for the payment, an employee must be in the course of employment and he or she must be an employee of the company or the organization to claim compensation from the employer of the company. So, what is doctrine of added peril? When an employee performs or does something which is not required by him in the course of employment and it adds added peril or danger, he or she may not be entitled for the compensation from the employer. Adjudication of compensation. The adjudication of the compensation is done by the commissioner, or it can be sent the quantum or the amount of compensation that will be given to an employee is judged by the commissioner. Self-inflicted injury. So what is self-inflicted injury? If a worker inflicts an injury to himself or herself, it is known as self-inflicted injury. The injury must be intentional or accidental, but the employer is not liable for such injuries to the employee. Contributory negligence. So, the employers are vicariously liable for the acts of the employee in the course of employment, but if there is negligence on both the parts of employee as well as employer, there is said to be contributory negligence and the employee will be entitled for the compensation only for the part the employer had been negligent. Okay, so what is contributory negligence in Employees Compensation Act? So, if we say if an employee is equally negligent as the employer, then the employee will get compensation only to that amount in which the employer was liable. Otherwise, it is said that both employer and employee has contributed negligence equally. Employer's liability in case of occupational diseases. So, for example, minors are at a risk of developing diseases. So, if the occupation is such that it can create risks for the employee, then the employers are liable in that case. A personal injury. A personal injury can be compensated by an employee only in some circumstances. For example, on the basis of age, sex, sexual orientation, color, nationality, religion and belief. In all these cases, the employer will be liable. Except these cases, the employer will not be liable in case of a personal injury. In case of an accident, the employer will be liable only if the accident is due to occupational diseases. So, arising in and out of the employment, the employee will get compensation only if he is in the course of employment. If he is doing something for personal benefit, then the employer will not be liable for the compensation. If there is a causal connection between the place of the accident and the accident where the employer is working, the employer will be liable in some cases under this act. So, willful disobedience of orders or safety devices. If the employee disobeys the order expressly given or denies to obey any rules, the employer cannot help it and he will not be liable because the rules are made for the safety of the employee. Alternative remedy under Section 3, Clause 5. An employee will not get compensation under the Act if he has instituted a case in a civil court in respect of the injuries suffered. Liability of an insurance company. So, an insurance company cannot escape liability to pay the compensation just because the company has not been issued a notice. Liability of an insurer. The liability of an insurer is determined on the basis of the wages of the employees. The amount of wages is covered under the insurance policy. The company will be liable to indemnify only that portion of amount which is under the wages. Method of calculating wages. The basis for the calculation of compensation is the monthly wage system. A term bata, which does not amount to wages for computing compensation, It is paid to workmen per day to cover special expenses incurred by him due to the nature of his work. Okay. The notice and claims of the accident. A claim for compensation cannot be entertained by a commissioner unless the notice of the accident is given by a certain manner. Medical examination of an employee. When an employee brings to the notice that he is met with an accident before the expiry of 3 days, he will be examined free of cost by a qualified medical practitioner. And if the employee refuses to submit himself or herself for the medical examination, his right to compensation shall be suspended. Remedies of employer against the stranger. When an employer recovers compensation as he suffered any injury and creates a legal liability of some other person other than the person by whom the compensation was paid, the other person will be entitled to be indemnified by the person who is liable to pay the damages. Insolvency of the employer. When an employer enters into a contract with any insurer in respect of a liability to an employee, and if the employer becomes insolvent or if he is not able to pay the compensation, the insurance company is liable to pay the compensation on behalf of the employer. The employee can also recover the amount if the company is winding up or in case of insolvency. Contracting out. So, if an employee has made a contract or agreement before or the commencement of the act, and if he voluntarily seizes the right to compensation from the employer, it shall be considered void and the employee cannot further seek any compensation from the employer. Appointment of commissioner. So who is a commissioner? Commissioner means a commissioner for employee compensation appointed under Section 20 of the Employees Compensation Act. The state government or the central government may appoint any person to be the commissioner for the workmen's employer, for the workmen or the employees. So every commissioner is identified as a public servant in the Indian Penal Code. Section 15A. Special provisions relating to captains and other members of the crew of aircrafts. If the captain of an aircraft is serving and he is the employer but an accident occurs, any crew member or the captain, it is not necessary for any crew member to give notice of the accident. In such cases, the death of the seaman or the master, the claim of compensation may be made within 1 year without the notice after the news of the death is received by the claimant. Section 15B. Special provisions relating to employees abroad of companies and motor vehicles. So, the special provision related to employees abroad in motor vehicles will be applied under the Motor Vehicles Act 1998. The notice of the accident and the compensation can be served by the company. In case the employee dies, the provisions under this section 15B will be applied. The claim for compensation can be made within 1 year after the news of the death of the claimant has been received. Reference to commissioner. So the question rises that who will pay the liability of the person under the act? So the liability or the compensation will be commissioner who is appointed by the state government or the central government. So defective application. So what is an defective application? So an application to a commissioner can be made if the applicant is illiterate or because of any other reason he is not able to furnish the information in written form, and then the application shall be in the direction of the commissioner. Powers and procedure of commissioners. Section 23. He has the power to award compensation more than what is claimed by the employee if the facts warrant the award. Section 25. Method of recording evidence. So, a commissioner makes a brief written message of the evidence of very witness as the examination process proceeds. The memorandum should be in the written form and duly signed by the commissioner. The form so signed by the Commissioner must be in his own handwriting and it will be a part of the record. Section 25A, time limit for disposal of cases relating to compensation. The Commissioner can dispose of the matter relating to compensation under the Act within a period of 3 months from the date of reference and intimate the decision respect thereof within the said period to the employee. What is substantial question of law? So, if there is any difficulty in applying the facts to the law, it will not amount to a substantial question of law. The reference case law was Asmith Bedi versus Marimuth. Section 32, power of the state to make rules. So, the state government has the power to make rules and regulations for the purpose of this act. So, state government ये कहता है कि कुछ intervals पे an application can be made under section 6 even when it is not accompanied by a medical certificate by a qualified practitioner. So, the state government prescribes a certain interval when an application can be made under section 6 even if it is not accompanied by a medical certificate by a qualified practitioner. Section 34, publication of rules. The power to make rules in Section 32 will be subject to the conditions of the rules which are made after previous publication. Rules so published in the official gazette will have an effect in the Act. Section 35, rules to give effect to arrangements with other countries for the transfer of money paid as compensation. The central government may make rules for transfer of money to any foreign country which is deposited with the Commissioner under the Act by a notification. A person who resides in a foreign country or is about to reside in the country may be awarded the money deposited under the law relating to employees. The amount related to fatal accidents shall not be transferred without the consent of the employer under the Commissioner. So it basically means any amount which is under the fatal accident cannot be transferred without the consent of the employer. Section 36. Rules made by the central government to be laid before the Parliament. Every rule made under the central government is laid before each House of Parliament while it is in session for 30 days. It may be done in one session or in 2 sessions before the expiry of the session. The Houses may make any modification in the rules or the Houses may agree that the rule should not be made. So, basically, the Employment Compensation Act is made for the employees so that they can incur expenses for the injury suffered. So, during an accident, the employee can get compensation from the employer. The basic rule of vicarious liability applies here. The employer is the master and employee is the servant. But don't forget the basic rule that the employee will get the compensation only if he has suffered an injury and he has suffered the injury in the course of employment.